In the matter of YUVRAJ LAXMILAL KANTHER versus the state of Maharashtra, court said that the trial court and high court fell in error in rejecting the discharge application of appellants for the reasons in the order of trial court dated 1 April 2017 and that of High Court dated 2 November 2017 were set aside and quashed. Court said in so far facts of the present case were concerned, the two deceased employees of appellant number 1 were undertaking the work of decoration in front side of shop. As part of said work, they were working on signboard, which was approximately at a height of 12 feet from the ground level. For this purpose, they were provided with an iron ladder. While working on signboard, they were struck by electricity, as a result of which they got electrocuted and fell down, resulting in multiple injuries leading to their death. It was purely accidental, court said. On these basic facts, no prima facie case can be said to be made out against the appellant for committing an offence under Section 304A of IPC, not to speak of Section 304 Part 2 IPC. In any case, trial court only considered culpability of appellants qua Section 304 Part 2 IPC as committing magistrate had committed the case to the Court of Sessions, confining the allegations against the appellant to Section 304 Part 2 IPC and not Section 304A IPC. Court said that even if we take the allegation against the appellant as correct, we are afraid no prima facie case can be said to have been made out against the appellants for committing offence under Section 304 Part 2 IPC. From record on the case, it was evident that there was no intention on the part of two appellants to cause the death or cause such bodily injury as was likely to cause death of the two deceased employees. It cannot also be said that the appellants had knowledge that by asking the two deceased employees to work on the signboard as part of work of decoration of the frontage of the shop, they had the knowledge that such an act was likely to cause death of the two deceased employees. As such, no prima facie case of culpable homicide can be said to have been made against the appellants. If that be so, the subsequent requirement of having knowledge that the act was likely to cause the death but not having any intention to cause death would become irrelevant, though we may hasten, court said, to add that nothing is discernible from the record of the case that appellants had the knowledge that by asking the two employees to work on the signboard would likely cause their death or cause such bodily injury as is likely to cause death. Therefore, the basic ingredients for commission of offence under Section 304 Part 2 IPC are absent, court said, in the present case. Court explained that Section 227 CRPC deals with discharge. What Section 227 CRPC contemplates is that if upon consideration of record of case and the document submitted therewith and after hearing submissions of accused and the prosecution in this behalf, the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for doing so. At the stage of consideration of discharge, court is not required to undertake a threadbare analysis of the materials gathered by the prosecution. All that is required to be seen at this stage is that there are sufficient grounds to proceed against the accused. In other words, the materials should be sufficient to enable the court to initiate a criminal trial against the accused. It may be so that at the end of the trial, the accused may still be acquitted. At the stage of discharge, court is only required to consider as to whether there are sufficient materials which can justify launch of a criminal trial against the accused. By its very nature, a discharge is at a higher pedestal than an acquittal. Acquittal is at the end of the trial process, maybe for a technicality or on benefit of doubt, or the prosecution could not prove the charge against the accused. But when the accused is discharged, it means there are no materials to justify launch of a criminal trial against the accused. Once he is discharged, he is no longer an accused.